When a person is unable to act on their own behalf, it means the person is incapacitated. There are two arrangements that can be made if a person is unable to act on their own behalf: a guardianship and a conservatorship. Minnesota statutes say that incapacity is proven when the petitioner, the person who is asking the court to appoint a guardian or a conservator, can provide evidence to the court that the proposed ward or protected person is unable to make responsible personal decisions, and that the proposed ward or protected person is unable to meet his or her needs. A legal guardianship is a legal arrangement under which one person, a guardian, who is appointed by the court, has the legal right and duty to care for another, the ward, because of the ward's inability to legally act on his or her own behalf because they are a minor or because of mental or physical incapacity. Minnesota statutes state that a guardian has the powers and duties over the ward's person. A conservatorship is similar to a guardianship, except that the conservator, who has been appointed by the court, has powers and duties over the incapacitated person's estate. A ward, as defined by Minnesota statutes, is a person who is under the custody or protection of another. Wards who have had guardians appointed are minors or incapacitated adults who are impaired to the extent lacking a sufficient understanding or capacity to make or communicate responsible personal decisions, and who have demonstrated deficits in behavior which evidence an ability to meet personal needs for medical care, nutrition, clothing, shelter, or safety. An incapacitated person is defined by Minnesota statutes as an individual who, for reasons other than being a minor, is impaired to the extent of lacking sufficient understanding or capacity to make or communicate responsible personal decisions, and who has demonstrated deficits in behavior which evidence an inability to meet personal needs for medical care, nutrition, clothing, shelter, safety, even with appropriate technological assistance. Protected persons in general are those individuals who have had conservators appointed for them because they lack similar capacity and have demonstrated behavioral deficits regarding their estate or financial affairs. Whoever the court determines is in the best interest of the ward or protected person can be appointed as the ward's guardian or conservator. The court will consider the following factors: who, if anyone, is the ward's current guardian, the kinship or familiar relationship between the ward and the guardian or conservator, the reasonable preference of the ward or protected person. Minnesota statutes say that the court is required to act in the best interest of the incapacitated person when considering who to appoint as guardian or conservator. Guardians and conservators must also submit to a criminal history and a background check. In order to apply for the appointment to be a guardian or conservator, a petition must be filed in probate court of the county of residence of the proposed ward or protected person. A court hearing is required. The proposed ward or protected person should be present at the hearing if possible. If the court finds that a guardian or conservator is needed, then the court will issue an order granting the petitioner guardianship, conservatorship, or both. At the hearing, the court may order the conservator of the estate to post a bond before the letters of conservatorship are issued. This will provide assurance that the ward or protected person's estates and property are secured. Letters of guardianship or conservatorship are evidence of the guardian's or conservator's authority to act on behalf of the ward or protected person. The court will want to order the least restrictive alternative to appointing a guardian or a conservator. This means that if a suitable alternative to appointing a guardian or conservator is available, the court may order use of that alternative instead. For example, if the goals of the appointment can be accomplished by setting up a trust or a joint bank account, the court will go that route in lieu of a full-blown guardianship or conservatorship.